going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. Hope you guys are having a great day so far. Got a good one. Judge Anzalone, I believe is how you pronounce it. I've heard her name pronounced a few different ways. But this dad is trying to get out of paying child support. At least that's what I think he's doing. Or he's just being, I don't know, a weirdo. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
This is in the matter of David Shorts versus Jessica Sue Shorts, file number 2020-47465 DM. I have Jenny R. Stone, P77883, appearing on behalf of the defendant. All parties are appearing via Zoom. We are here today on plaintiff's objection to the referee's recommendation and order. Both parties petitioned for a referee hearing regarding the issues of child support and parenting time. The referee determined there was no reason to modify the parenting time schedule. The referee did determine that it was appropriate to change some parenting time conditions, adding a licensed driver whom the children are familiar with must transport the children. Parenting time exchanges will continue to take place in Albion. Neither parent will record parenting time exchanges. Neither parent will disparage the other parent or anyone in the parent's household in front of the children. Neither party will discuss enrolling the minor children in extracurriculars with the children without first discussing with the other parent. Neither parent will schedule summer activities outside of their own parenting time without the consent of the other parent. And the parent will forfeit a parenting time phone call made later than 5:15. They also entered a uniform child support order. Mr. Shorts, you objected to everything as you essentially allege that defendant mother is alienating the minor children and you're indigent, so you can't afford support. You did provide, thank you, a very thorough brief. Some of the things I wanted to talk to you about is what is, let me look at your judgment support.
Your Honor, may I add one thing real quick?
Yeah.
So we did file an objection as well. I called and I got a court date of August 19th of 2024 at 9 a.m. We mailed it in on the 26th and I served a copy to Mr. Shorts. In the meantime, he must have gone to the clerk's office, filed an objection, and he got this date. So it's my understanding we have two different dates for objections, but both plaintiff and the defendant have filed an objection.
Yeah, I know that. I was just going through his.
Oh, okay. All right. Just want to make sure
that
because
you,
we have the different
you
dates.
have an objection that she wants to be able to enroll the children in extracurriculars during the school year. That's your objection,
Yes,
right?
Yes.
Yeah,
Just clarification.
Yep. I just hadn't gotten there yet.
All right. Thank you. Sorry.
That's okay. Let's see. So Mr. Shorts, I was looking back at the judgment. Let's see here. Let me find the judgment of divorce. Somewhere back here. Oh, this is a second file. So Mr. Shorts, are you saying that there's a clause in your judgment of divorce that the parties be required to leave 50% of their estate to the children?
Yes, there is a clause in our divorce that states that. And at the time I was, I didn't have any future plans of meeting anybody else or moving forward. And now that has happened, because I am still young, I do have a daughter, biological daughter that I have to include in that stuff. And it just doesn't work, that.
Okay, so Mr. Shorts,
I don't really understand how that would work. Maybe I'm not understanding exactly how what they're saying, but there's a clause that he has to leave 50% of his estate to his kids. He's going to say it here in a second. He's got another kid, which he kind of said it in a way right there, but he'll confirm it. So just throw 25% on that kid. That's 75%, and then 25 to, I don't know, your spouse if you have a spouse. I don't really understand the issue here. I really don't.
Go back and change the judgment of divorce.
Okay.
I mean, once the judgment of divorce is entered, it's entered, and that's it.
Okay, so then I'll just leave everything in my future wife's name, and I'll put it in a living trust to where nobody can touch it. That's fine. Because no courts can go against
So,
those.
and then you said that you are entitled to a jury trial and the issuance of a child support order, and no, you're not. You're not.
So you guys are allowed to go against Supreme Court law, is that it? Because it's under a you can't have something without due process in a jury trial.
So no, none of that's true.
Really? Because I just beat a case and had 2 cases nollied and dismissed under judicial clause. Like, what
Okay.
jurisdiction?
So child support is entered, you had due process, you had hearings, it was entered, you provided your financial information. If you're indigent and not working and you can't afford your child support, the resolution of that is to get a job. So no.
I am working, but the thing is you as a court do nothing for me. You as a court have failed me miserably. You as a court also told me that the Michigan Child Custody Act is a private act. It's not, because if it was a private act, it wouldn't be on your website through Lenawee County as a handbook. It wouldn't be across the state and every other county as a handbook. You as Lenawee County fail people miserably and don't protect others.
None of that really applies. So thank you. And
Okay,
then
let's take it to it. Let's push it to a Supreme Court matter, Your Honor, because you
so
do not.
You can do that. You do have the right to appeal this to the Court of Appeals, and you have every right to do that. But
I want this whole case dismissed under judicial bias because you used to be my court-appointed attorney back when I was 17, and I don't feel I have a fair trial through this court. And
so, Mr. Shorts, I represent.
All right. What are they even talking about? You want the jury trial for this is I don't know what I don't really know what this case is about. I thought it was child support. Now they're arguing different things that are, I don't know, but this guy's just out of his mind. Yeah. When you were 17, I'm pretty sure I'm going to guess in your 30s now. Just going to guess. I don't know. Let's just play.
Represented more than 10 people a week for a period of 10 years. I may have represented you. I don't remember you. It wasn't on this case. And so there's a 5-year period that has passed. So Mr. Shorts, I'm not going to recuse myself because I represented you so many years ago on a completely different case. So no.
I feel that I'm not getting a fair trial because of it, so I'll turn it into the JTC.
This isn't a trial. This is an objection hearing. And I would grant your request if it was something I was able to grant you relief on, but these are things I can't grant you relief on.
You are allowed.
I have to follow the law.
Okay, well, so do I, because I've been seeking help because I can't afford it. So yes, I do go to other lawyers and seek help. And
excellent. Also, so when you can hire that attorney to do an appeal if you'd like. But so just to make a thorough record, I can't go back and change a judgment in divorce based on the reasons you said. I cannot give you a jury trial on child support. And yes, the referee does does have the right to issue a uniform child support order. If you wish to appeal that, feel free. So Ms. Stone, what you're saying is your objection will be heard on the 19th of August?
We were hoping that we would be able to address all matters today because it does deal with sports that start just prior to school.
I object to that. Absolutely not. I had to wait for your guys' stuff that you ejected. It is not for that matter.
So Ms. Stone, all right, Mr. Shorts, Ms. Stone, we'll hear it on the 19th. All right.
Thank you, Your Honor.
All right, thank you, Mr. Shorts and Ms. Shorts, Ms. Stone.
Okay,
Thank you.
wait a minute. Why am I being dismissed? You haven't even gone through my whole entire case, so you're just gonna go ahead and dismiss it and not even go through the whole process?
Those are your objections. That's all I received.
Really? Because on the back of that, there's a quorum non-judice, and you haven't even spoke about that.
A what?
That's exactly what I was going to say. Oh, what? I have no idea what that is. I actually meant to look it up before I started recording this video. I completely forgot. I still don't really know what he's saying. All right, I'm going to let this video play out. You guys are awesome. Have a great rest of your day. Until next time, bye.
Quorum non-judice. It's in the packet that you have, Your Honor, and you haven't even spoke on it. Any
Because it
judicial
doesn't apply. Mr. Shorts, we're done for today. Thank you. Okay, bye, Ms. Stone.
Thank you.